I have a couple difficult questions for you all, and I think it's important. So recently, CISA, under the Department of Homeland Security, issued a advisory to states that are utilizing the ICX machines, and I think there's 16 states that are doing so, including us. It surrounded the software 5.5A, as I recall it, and it's my understanding that we use a Louisiana-specific software that's 5.12. And if I get the numbers wrong, but correct me. But can you talk about those vulnerabilities and the Haldeman as much as you can? Because I know y'all are in litigation on this, and I sued to intervene in that case to be able to get the Haldeman report, and both the Georgia Secretary of State and opposed me, and then the judge denied me. So we ended up waiting for 4 to 6 months before we can even get any information, and I don't feel like we've probably gotten all the information, because it's my understanding the report is still under seal. And so until the judge releases that, we're not going to be able to get the full report. So can you address that for us here and now, so we can, and I'm sorry if it doesn't, deal with the procurement. I just still think it needs to be addressed, because I have y'all here, and it's been difficult to communicate because y'all are stuck in lawsuits. So if you could talk about the CISA report and what they released and how they addressed it, and how you think your company believes that Louisiana is not susceptible at this time.
So you're correct. It's still under seal, so it can't be shared at this time. CISA did get a copy of it. They were allowed to look at it. So the report that they came out with, the advisory that came out, was based on potential vulnerabilities. And I think it's important that they don't believe any of these have been exploited, and for folks to understand that the researcher was given unfettered access, given passwords, given login information, given manuals, and given a substantial amount of time to basically do whatever he and they wanted to do to the system. So like most systems, if you have that kind of access, you're going to be able to find something. So I think some of the issues that or concerns that were raised, one of them is like the trusted root certificate that they talk about utilizing to identify software being loaded onto the system. So that was not an EAC requirement. This is where we find ourselves in a little bit of a situation where most systems, I don't know that any of the other vendors built their systems utilizing this trusted root certificate. There are other ways to validate the software being loaded, but specifically that was not a requirement. And I think it's important, and the EAC put out a letter to their customers, and I'll just read a quick, which might help from that. Additionally, the EAC's review of the CISA advisory and underlying security researchers report has not identified any nonconformities with the voluntary voting system guidelines under which this component was certified. Decertification actions against this system are not being pursued. So the EAC actually finds himself in a situation where some of the stuff that is raised in the report is not part of the certification process. Now, whether moving forward, and obviously we as a company intend to address all those in a future version to be released, and we're working with the EAC on expediting that timeline, and it'll be a good test for the EAC, because I think we're in a different world now. When the way 2016, when the Russians came into our voter registration systems, and attempted to attack that, we are now seeing the vulnerability disclosure program coming about, and that is going to be something that's going to impact all vendors, and it's going to be something the EAC will have to address on an expedited basis. So our intent is to address all these issues with the future release and get that release out to everyone. In many of our systems, they're already addressed. Some of our newer ones, especially states that do not require the EAC certification, we are able to address these in those states that just require the testing lab to test it. So a good number of these concerns, vulnerabilities have been addressed.
So when this all came out in the court case and before the judge sealed it, were y'all aware of the Haldeman report at all?
I think and I can speak to that a little bit. So I'm relatively new, but it took a while for even the company to see that actual report. And then, as you can understand, prior to the CIS advisory coming out, we weren't allowed to talk about it because it was under seal. So it put us in a kind of a difficult position where we weren't allowed to talk about what we could talk to CISA because they were allowed to see the report. And only a handful of people in the company have even seen the report.
So, but the requirement in the contracts is that you all advise your clients of potential vulnerabilities, and we didn't get one.
I would have to defer that to the legal, like where, because it's under seal that makes it. I don't have an answer for that. And we can get an answer for that, but why, from a legal standpoint, why that was not released?
Well, it's and this is from my discussions with CISA, and that is that you all were made aware and or the judge allowed you all to see the report, I think in December, correct?
I believe that's about the time
So
frame.
did the judge refuse to allow y'all to alert your clients that there were potential vulnerabilities and to come and visit with us about it?
I'd have to get back to you on that. That's now we're getting into because of the court case and the legal issues, and like I said, I just came on board, so I don't want to speak to something and give you any misinformation.
Sure.
So.
Well, and I just want to put on the record this. I sent a letter knowing about the vulnerabilities, asking Dominion to bring in employees, whatever they needed, to come in and inspect these machines, open them up, and show us what the vulnerabilities potentially were, which I thought was a contractual obligation. And you all, and I don't mean you, the CEO of the company tells me to go to a testing lab.
Okay, I'll bring that back as
I appreciate
discussion.
that.
Yep.
I just want to put this on the record, and it's my frustration, and y'all are getting it right now because y'all are here. For a judge, I don't care, federal or world, it doesn't matter to me, to withhold important information to the people of Louisiana because she's worried about feeding conspiracy theories. Well, she fed the conspiracy theories even more, if not creating the reality of the situation we're faced. And then the Secretary of State of Georgia opposing me, the Secretary of State of Louisiana, from even intervening to get the report to be able to deal with it. I've been in contact with Dr. Haldeman more times than I care to think of, and the poor man can't even tell me everything, and he's willing to help us when nobody else could or would. And that is frustrating, especially when we were made critical infrastructure. We opposed it because we thought the federal government was going to interfere and nationalize our elections. It didn't happen yet. But what is going on is that they don't even know, the left hand doesn't know what the right hand's doing. CISA didn't involve EAC in any of this dialogue. Mm-hmm. And so they missed a number of components to it. And they didn't want to they were going to release it to the public without even talking to the 16 affected secretaries of state and tell us what's in the report, which turned out not to be enough for us to deal with. But the bottom line is I have a job to the people of Louisiana, and right now I'm handicapped by a federal judge and a federal government. And our elections aren't supposed to be nationalized?